president and CEO of the National Constitution Center, your first challenger. And he's author and journalist, constitutional expert, and I think he's going to talk to us a little bit about how this old document is relevant in our lives today. Would you please join me in welcoming Jeff Rosen? Jeff, are you back there? All right, here he is, a little louder.
Good to see you.
The stage is yours.
Thank you so much. Ladies and gentlemen, I'm so honored to be here and so thrilled to issue the first challenge. And I'm going to challenge you to educate yourself and your classmates and ultimately the entire country about the most inspiring document of freedom ever created, and that is the U.S. Constitution and the Bill of Rights. I have the great privilege of leading the only institution in America which is chartered by the U.S. Congress to promote debate and education about the U.S. Constitution. Our charter says that our responsibility is to disseminate information about the U.S. Constitution on a nonpartisan basis. And to achieve that inspiring goal, we have three missions. We are the Museum of We the People, we are America's Town Hall, and we are a Center for Civic Education. And I want to tell you a little bit about each of those goals and how you fit so centrally into each of them. So as the Museum of We the People, we're a beautiful museum in Philadelphia. If you come to Philadelphia, please come visit us. It's a gorgeous building right across from Independence Hall, where the U.S. Constitution was drafted in 1787. And you can come to our beautiful glass building and look across the mall on Independence Hall. You can see the Liberty Bell, which is right next to us, which rang when independence was declared. And starting next fall, when you come to visit us, you can see one of the 12 original copies of the Bill of Rights. When the Bill of Rights was drafted, President George Washington sent out one copy to each of the 13 states and one to the federal government so the people could decide whether or not to ratify these crucial amendments to the Constitution, which opponents of the Constitution thought were necessary to protect the fundamental freedoms of Americans. Remember, when the Constitution was drafted, all of the states had bills of rights of their own that protected things like freedom of speech and freedom against unreasonable searches and seizures. But there was no Bill of Rights in the original Constitution because the people who wrote it thought, well, if you write down certain rights, then some people might say that if the right isn't written down, it's not included. And that would be dangerous because it could shrink liberty. And also, people said it was unnecessary because the states already had their own Bill of Rights. Well, a bunch of opponents of the Constitution said, that's not good enough. We've got to have a national Bill of Rights to ensure that our fundamental rights are protected. And the Bill of Rights was drafted. George Washington sent it out to the states. And at the National Constitution Center, we are going to have one of those 12 original copies. And you can come see it and debate it. And this is going to be the basis for 3 years of debate and education about the Bill of Rights during its 225th anniversary. So that's the first thing we are. We're this great museum of We the People. We're also America's Town Hall. We are the only place in America that brings all sides together to debate the current constitutional issues that are in the news every single day and let citizens make up their own minds. I'm a law professor. I've taught constitutional law for a long time, and the longer I teach, the more convinced I am there are no right answers to constitutional questions. There are good arguments on both sides of all of the issues that are transfixing Americans in the news every day, from the constitutionality of NS surveillance to the scope of the right to bear arms. And your job as citizens is to learn enough about the arguments on both sides so you can make an educated judgment. And our job as the National Constitution Center is to bring together the most thoughtful proponents of each of these arguments and create debates. And these debates take place at Philadelphia, and on the web, and on radio, and on podcasts, and on video. And you can come to our website and watch these debates and educate yourselves and decide what you think. And finally, and here's where you come in, and this is why I was so excited to fly to Denver this morning just to be able to talk to you. We are a Center for Civic Education dedicated to promoting civic engagement. Our job, our congressional charter, is to inspire school people like you from around the country to educate themselves about the Constitution and the Bill of Rights and to teach others about why it's important. And that's my challenge to you. I want you to take a provision of the Bill of Rights, I always carry it with me, and this is the National Constitution Center's great pocket constitution, and I'd be glad to give each of you one, and you can also find our interactive constitution on the web. There are 10 amendments in the original Bill of Rights. You can pick the one you think is most relevant to your lives. You can learn about its history, and then pick a contemporary challenge, a court case, a national controversy that centrally relates this freedom to your lives, and tell what you think the right answer is. So let me get specific. I could give you so many. I'm going to give you 4 or 5 examples of ways that the Bill of Rights relates to your life. But my challenge is, your job is to, you can talk more about those or you can find some other ones. So let's start with the 4th Amendment to the Constitution, because that's in the news every day nowadays. Here's the 4th Amendment. It says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." What does it mean for us to be secure in our persons, houses, papers, and effects in an electronic age when many of us can be tracked 24/7, when so many of our movements are recorded on Facebook, on Snapchat, on Instagram, and are archived and stored and can be later resurrected? So I was just yesterday in Silicon Valley talking to people at Facebook and Google and Twitter. And they said that before too long, they imagine that all of these camera feeds that all of us are taking on our iPhones, and increasingly on technologies like Google Glass, which you know is this wearable technology that's going to allow me to walk up to you and we're talking, you don't know if it's on or not unless you see the light. And maybe our conversation is being recorded right now, and if you haven't given permission, maybe I could post it to the web. And say I post our conversation to the web, and you guys all post your, Snapchatting me or taking pictures of my talk, and all these pictures are posted and put on the web, and then you add to that the drone cameras that can fly in the air that are no bigger than tiny little insects and can track people 24/7. Police departments are now using these drones to go up on a suspect and track his movements 24/7 for a month and resurrect his movements. Let's say the Google and Facebook people imagine that all of these camera feeds are put live on the internet and archived and stored. If that happened, then you could click on a picture of anyone in the world, say you, or even worse, me, and then you could back-click on me, let's do that in the example, to see where I came from yesterday, which I said was Silicon Valley, Google and Facebook. A forward click to see where I'm going right after this talk, which is home to my family in Washington, D.C., and basically track my movements 24/7 for an entire month. Let's say the NSA decided to start following me, not because I've done anything wrong, because they thought I might be suspicious. I'm wearing a kind of pink tie and I don't know, I look a little weird. Would that be a violation of the 4th Amendment? Would it violate my right to be secure in my persons, houses, papers, and let's call them electronic effects, if the government started tracking me 24/7 on this Google, Facebook tracking system? Well, in order to answer that question, we could take a vote right now, but I think you've got to educate yourself a little bit before you can answer that question. You want to read a little bit about the Supreme Court cases on this question, and there's no Supreme Court case directly on point, although the court did hear an important case just a few years ago involving GPS tracking, global positioning tracking, where the cops put a GPS device on the bottom of a suspect's car and tracked his movements 24/7 for a month. Well, in that case, I hear a gasp over there, and that's basically what the court held too. The first question actually out of Chief Justice Roberts' mouth was, when the oral arguments started, the government, the Obama administration, said, citizens have no expectation of privacy in public. If you walk down the street, you assume the risk that anyone could be following you or taking pictures of you. Chief Justice Roberts said, is it the government's position that you could put GPS devices on the bottom of my car and track my movements 24/7? The lawyer said yes. At that moment, he lost the case, basically, because when justices imagine their own privacy being violated like that, they think it's unreasonable, and the court, 9-0, all 9 justices rejected the claim that there's no expectation of privacy in public. But they divided about the reasoning. 5 justices said there was a physical trespass involved. The police had to physically put a GPS device on the bottom of the car. That was the problem, because the framers of the Constitution thought any physical trespass designed to obtain information would have been a search. 4 justices went further. They said physical trespass doesn't help. You could have gotten the same information just by subpoenaing the guy's cell phone records. All my geolocational movements are stored in my iPhone. You could track my movements 24/7 without putting a GPS device on the bottom of my car. Just get my iPhone records. So those 4 justices said it was the amount of information that could have been revealed that was the problem, not the physical trespass. You're going to have to decide what you think is the right answer, because in my example of being tracked on Google and Facebook, no physical trespass, you just sign on and track my movements. So that's why I want you, if you like that example, learn about the history of the Fourth Amendment, hear the good arguments on both sides, and make up your own mind. This is not a hypothetical situation. The biggest controversy in this country right now is whether or not it's okay for the NSA to listen in on all of our phone calls, domestic, international, and to collect the phone numbers we dial. It's called the metadata. And what's so interesting about this case is that judges have disagreed about the right answer, as they do in all hard cases. One judge in Washington, D.C. said, absolutely, it is an unreasonable search of our persons and electronic effects to record the telephone numbers of every single one of the millions, hundreds of millions of phone calls that go in and out of the United States. He said, because we do have an expectation of privacy in our phone numbers, because you can learn so much about someone by reconstructing the phone numbers you dial. You could learn the political rallies you're interested in attending, or the people you hang out with. And the framers of the Constitution said this judge would have been appalled. They were centrally concerned about King George breaking into people's houses and reading their private letters to try to identify political dissidents. This judge said, it's the same thing. This is like the general warrants, they were called, warrants that didn't particularly specify the place to be searched or the things to be seized, that upset the framers of the Constitution, and this is unconstitutional. Another judge in New York came to the opposite conclusion. He said, we don't have an expectation of privacy in the phone numbers we dial. We know, after all, the phone company is recording them. It doesn't reveal all that much about us. The Supreme Court said in a case in the 1970s that the numbers we dial are not protected by the Constitution. Therefore, he said this is fine. So here you've got 2 judges, 2 smart people, thoughtful people, disagreeing about whether or not this is unconstitutional. The Supreme Court may well decide the question. I'd love to know what you think. And you can do this. You go onto the internet, read those 2 opinions from those 2 judges. Read that Supreme Court opinion about the GPS tracking. This is not, you don't have to go to law school to make up these cases. You have a responsibility as citizens to learn enough about this history in this beautiful document to make a decision about the most important question about privacy that the country is debating right now. So that would be one way of taking up my challenge, to decide what you think about NSA surveillance or about ubiquitous tracking in public. Or if you're interested in the Fourth Amendment, you can go closer to home. There are incredible cases involving the search and seizure rights of students in schools. So just a few years ago, there was a case involving Savannah Redding, who was an 8th grade student, and she was strip searched because school officials thought she might have in her backpack some non-prescription ibuprofen. That was what they suspected. One of her classmates said that she was carrying this non-prescription drug. It wasn't clear exactly whether the other classmate was out to get her or not, but the officials thought maybe she had it based on nothing more than the say-so of this other student. And they took her into a back room, and they basically strip searched her. They looked in her underwear to see whether or not she had this. Exactly. You're gasping. Why do you gasp when you hear something like that?
Just because that's like her personal space. That's like her body, and they didn't talk to the parents first, and they took her in a back room. That's kind of like, that's weird, but that's against her personal, her space. Yeah.
That's beautifully put, against her personal space. It's an unreasonable search of her person. That's literally what the Bill of Rights says that you can't do. We have this certain amount of bodily integrity that the Bill of Rights protects. They took her into a back room, didn't talk to her parents. It's unreasonable. That's what you're saying. There was another gasp at this table. Why is it unreasonable?
Like exactly what she said, that's like her body, they didn't ask the parents, and I just think that's unreasonable for somebody to do that, so.
Well, we've got 2 people who think it was unreasonable and it was her personal space. Anyone disagree? I said there are 2 arguments on any side of any hard constitutional question, so don't be shy. or even just for the sake of argument. Lawyers are supposed to be able to argue it round or argue it flat. If you were trying to make the argument on the other side, maybe you don't have to believe it, what would it be? Yeah.
It would be for her safety, maybe?
Excellent, for her safety. After all, it's a pretty dangerous drug. She could be selling it or sharing it with other students. You don't know that, but it could be so dangerous that, the argument is that you need to search. All right, well, we've had, this is basically, you've heard the best arguments on both sides. The constitutional law doesn't get all that much more complicated than this. There are a lot of legal jargon if you read the briefs, but basically, the argument on one side is it was her personal space, and it was unnecessarily intrusive. And the argument on the other side was it might be necessary for her personal safety. Now I'll tell you what the Supreme Court said. Basically, 8-1, they sided with the schoolgirl, with Savannah Redding. They agreed with both of you. They said this was completely disproportionate to the supposed threat. It was an invasion of her personal space, and that searches in the future should be proportionate, and their intrusiveness should take into account the age and the sex and the circumstances of the person who's being searched. And it was especially humiliating for a young girl to be searched this way. One justice, Justice Clarence Thomas, agreed with you in the back. He said that safety is important and that school kids have to surrender certain rights in the interest of safety, and therefore it was okay. So that's what the Supreme Court said. That would be a great thing to learn about as well. Just talk about searches in schools and what are the circumstances under which it's okay to have these searches, and do you agree or not with the court in this strip search case? I'm going to talk about one other amendment, and then I want to have your questions and answers. Before I do that, who agrees with a majority of the Supreme Court that it was an unreasonable search of this schoolgirl? And who thinks that it was not, that it was a reasonable search? All right. And just since I'm curious, who thinks that it would be a reasonable search if the government, when I leave this room to go back home, were to start tracking me 24/7 with a drone camera without any suspicion? Who thinks that that would be an unconstitutional and unreasonable search of my person? And who thinks it would be okay? Good. Tell me, excellent. Sir, tell me why it's okay.
I feel like if you were a suspect of the United States, I feel like if you were somebody that could be a threat to other people, then I would have no problem at all with you being surveillanced and being watched. But I mean, if you're a regular man doing nothing wrong, then I don't see why you have to be searched.
Excellent point. So if there's a degree of reasonable suspicion or probable cause to think I'm a bad guy, then it's okay. But if there's no suspicion, then it's not. Very good point. And that coincides with really what that judge who struck down the telephone call said as well. He said, if there's some real reason to believe this is a bad guy, it would be fine. But if you're just sucking up the data of hundreds of millions of innocent citizens who haven't done anything wrong, it's not okay. What is your view?
It was the same thing as his, It's just, if you're a suspicious person, then you have to reach
The very good point was if you're a suspicious person, you have something to hide, but if not, then you don't. Now, the government, though, has taken the position that you don't have to be a suspicious person, that basically this data is so interesting to stopping bad terrorism in the future that they're allowed to get it from everyone, even if they're not suspicious. Does anyone agree with that point of view? That basically it's okay to collect all the phone data and to store it because it might be useful in the future for stopping terrorism. Yes, sir. What's your argument for that? And this is a good argument. A judge has definitely endorsed this, so it's a very respectable position.
Well, I agree with that because you really don't know who's a terrorist, who's not, who's doing good, who's doing bad. You just don't know. You can't judge people just by how you see him. You might say, oh, he's a good guy, but ends up he's a bad guy. So you really don't know who to go with, who not to go with.
Great point. You may be looking for a needle in a haystack, but terrorists are hard to discern. They're good at concealing themselves. And if this system really works in identifying terrorists, given the huge threats it is preventing, the terrible threats to public safety, it might be worth it. Now, the way you put it, would it matter whether or not it works? that it's effective in actually catching terrorists? Is that an important part of your analysis? It's not. It might be useful, so whether or not it's... Invasion is one thing, but surveillance for safety is another, and safety is so important that it's not unreasonable to do surveillance if it might stop bad acts, even if you don't have really good evidence that it does. This is, you're very well stating basically the position that the US government has been taking in court, and if you read that New York opinion, I think you'll find a lot to agree with. All right, that is great, and I want to go to, we've started our question and answer. I want to just introduce one more series of challenges that you might think about, and we'll continue to talk, and that's the First Amendment. We all think we know what the First Amendment is. Let's read it once again with our great pocket constitutions, which I hope you don't have to carry the paper one around with you, but if you go to constitutioncenter.org, you can find our great interactive constitution and always have it next to you at all times. I can't go to bed without having the Constitution right under the pillows, so it's a very good thing to have with you at all time. Amendment 1, Congress shall make no law abridging the freedom of speech or of the press. Congress shall make no law abridging the freedom of speech or of the press. What does it mean to abridge freedom of speech in an age when most of our freedom of speech takes place not on soapboxes where people are kind of making speeches about the government? It takes place where? Where are our free speech places today? Where do we communicate in? One more time, because social media, Google, Facebook, Twitter, those are our platforms of freedom of speech. That's the place where we share more than 1 billion pieces of content a day, according on Facebook. Hundreds of millions, the Twitter people said 500 million tweets. Just the volume of speech would have thrilled our founding fathers, who were so excited about the possibility of we the people governing ourselves and expressing ourselves and communicating and sharing and persuading in the rich marketplace of ideas. In one sense, the internet is just the apotheosis of the hope of our founding fathers in empowering each of us as citizens to stand up for ourselves. But on the other hand, this new world of the internet is raising vexing and deep problems about the limits of free speech in an age when Google and Facebook have more power over who can speak and who can be heard than any king or president or Supreme Court justice. If you want to do the First Amendment as your challenge, let me tell you this story. There was a woman not long ago who's a teacher in a high school, and her name was Stacy Snyder, and she taught in a high school in Pennsylvania. She posted on her social media page, I think it was MySpace, a picture of herself in a pirate hat drinking from a plastic cup. And she put on the caption, "Drunken Pirate." This was just for her friends. She was kidding around. We don't even know if she was drinking. She just was at a silly party, said "Drunken Pirate." Her supervisor saw this, said, "You're promoting underage drinking. This is unacceptable. You're fired. You can't be a teacher." She said, "What are you talking about? I'm about to graduate from teacher's college. This was my free speech right. I wasn't exposing this to my students. This is an abridgment of my First Amendment rights." She sued, and a judge disagreed. He said, although she's a public employee, her speech wasn't on a matter of public concern. It was a private matter. Therefore, she had no free speech right, and therefore she's out of luck. She never graduated from teacher's college, never became a teacher. She has a totally different job today. What do you think? Is that an abridgment of our right, which says that Congress shall make no law abridging the freedom of speech? Was it an abridgment of her freedom of speech to be fired for posting this silly picture on MySpace? I hear a yes. Someone tell me why it is. Yes, sir. Why is it an abridgment?
Hey, how are you? Sorry. Could you stand up?
Because the whole situation was based off of nothing but assumptions. Nobody was sure whether she was really a drunken pirate or not. She was just putting up a joke. And honestly, if that's offensive to present to a younger audience, then there's too much stuff all over TV. If her joke is something, because you could catch stuff on SpongeBob too, that you'll be like, hey, that kid shouldn't be hearing that.
Great, that's a very great point. That was a pretty mild joke compared to what you can see on SpongeBob too. Her supervisors were making assumptions. It might have been, Diet Coke in that cup. and therefore you think it was an abridgment of free speech rights. What's the argument on the other side? That it was not an abridgment?
So I think that whenever we're talking about freedom of speech, there's always this idea that you have to understand that when you're speaking freely, that you're putting it out there for interpretation, and that's a risk that you take when you speak freely. And so because of that, once she spoke like that and she put that out there on the internet, it was something that she had to have been able to understand was going to be interpreted in many ways as speech is when we speak freely. So that's something that you have to understand when you're speaking. And you could say anything on the internet and anyone could look at it and interpret it differently, and because of that, you have to accept the repercussions.
Very well said. That's a good way of putting the argument on the other side. The right to speak freely doesn't mean the right to be free from the repercussions of your speech. If it's a legitimate school requirement that teachers behave in an appropriate way, then they can be held accountable for behaving inappropriately. The founders of the Constitution, it turns out, took an even more rigorous version of the argument that you just expressed, and some of them thought the government doesn't have the ability to stop you from speaking in advance. They can't prevent you from printing a book that criticizes the king, but they can definitely throw you in jail for publishing that book after you've published it. So that some people think that the First Amendment was really just a prohibition on prior restraints, stopping you from speaking before you actually do it. But once you press the send button, then according to this view, you can definitely be held accountable. So lots to say about this MySpace question, but I'd love to hear your thoughts if you accept my challenge about the First Amendment. One last First Amendment example. I was at Facebook yesterday, as I said. The Facebook executives are just overwhelmed with the question of what speech takes place at school and what takes place at home in cases involving discipline and cyberbullying. So you may have come up with this yourself, but the Supreme Court basically said you can be disciplined for speech that you engage in at school if it causes substantial disruption to school discipline. On the other hand, you have some rights too. You're allowed to wear a black armband protesting the war. The Supreme Court says that's okay because it doesn't cause substantial disruption. If you do something that substantially disrupts school, you can be punished. But what does it mean to be at school in an age when much of our speech takes place on our laptops at home, reading platforms that we may be assigned in class? So there are cases on both sides of these questions. There was a young girl in elementary school who wrote something on Facebook criticizing our high school principal. He sued. He said that she should be disciplined because he didn't like what she said. The court said because she was at home and it was her computer, it's fine. Another court came to the opposite conclusion and said when a girl wrote something really nasty about a friend of hers and bullied her in a way that really upset her friend, that even though it was at home on a personal laptop, the student should have anticipated that it would be viewed in the school environment, and therefore she could be held liable. Some people have said you should take a kind of geographic approach. If it's on school property, on school hours, you can be punished. If it's at home on your personal computer, it can't be. But the courts are all over the map on this question. There is no clear right answer. I would love to hear your thoughts on that challenge. All right, so you can see what I have in mind. This is why, you know what, you're going to hear 2 days of great challenges. This is the most important challenge. Forget about all those other ones. They're wonderful, they're inspiring, but it is so important, it's more important than anything else, that you understand not only the historical sources of your rights, but how they apply today. Because if you don't do that, you cannot be engaged citizens and you cannot make up your own mind. So I'm going to read my challenge in a moment. I'll read my challenge and then I'll tell you what I want you to do. So to read my challenge, I have to look, I can't read it back there. I'm going to look on my iPhone so I can read it. Oh, but here's my challenge. This is wonderful. All right, it's very exciting, so get ready. Ladies and gentlemen, I challenge you to create a way of inspiring your classmates and students around the country to learn about the Bill of Rights, its history, and this is most important, the way that it relates to your own lives. Inspire them to apply their knowledge of it, to be active citizens by choosing a current debate involving the Bill of Rights and making an argument about what liberty means to you today. Be creative in helping students learn about where their rights listed in the Bill of Rights came from and how they have evolved over time. I am so hopeful. Do we have more time for questions? Or? 4 minutes. 4 minutes for questions. Basically, what I want you to do is just what I said. You can pick any provision in the Bill of Rights. There are 10 of them. Choose the one that you think is most important. Learn about its historical roots. And then most important, pick a current controversy in the news, in your schools, in your community. Figure out what the best arguments on both sides are. Be fair-minded about recognizing the strongest arguments on both sides, and then say what you think the right answer is. And here's the part that I really would appreciate your help on. Figure out a way of inspiring students throughout Denver and around the country to do the same thing. I'd love for the winning team, if you choose my challenge, to come up with a model, a curriculum, a way of building teams, a way of enlisting other people to do the same thing so we can build these laboratories of democracy, to use my hero Louis Brandeis's phrase, that will help what you're doing here in Denver to expand around the country and ultimately around the world. So that's my challenge, and we have just a little time to talk about it.
Any questions? More questions, Jeff? Over there.
Yes.
We have time for maybe just 2 or 3 questions.
Please stand
What's up, man? What is like your opinion on the NSA like spying in on us?
I laugh only because I'm, as head of the National Constitution Center, I'm supposed to present both sides of these issues. I have to be nonpartisan, but you asked me what I think, and I'm happy to tell you. I agree with the judge who said that this is an unreasonable search and seizure. It seems to me that collecting masses of data without individualized suspicion is exactly what the framers of the Constitution were concerned about. There was a famous historical controversy called the Writs of Assistance, where King George was forcing people to help the king's agents in breaking into people's houses and enforcing customs duties, because he was afraid that the people in Boston weren't paying taxes. And there was a speech against the Writs of Assistance made by a guy called James Otis that was so inspiring that John Adams said, at that moment, independence was born. And James Otis basically said our liberty should not be at the discretion of some petty officer. It shouldn't be up to some NSA officer without any judicial oversight to decide what he or she thinks is dangerous. And I agree with the judge who said that this is just like the Writs of Assistance and that it should be struck down.
My question is, I got an impression you really like the Constitution. So I would wonder if you would agree with the argument that, that the Constitution should be rewritten in our day and age, considering that, you know, how much cultural norms have changed and that the founders wrote the Constitution for themselves, not for like people and the world as a whole.
I love that question. And Thomas Jefferson would have loved it as well, because he believed that every constitution should be rewritten every generation, and that it was inconceivable that the rights of the people could stay current unless there was rethinking. I think there is a serious argument that the Constitution needs to be, if not rewritten, at least amended. In an age when Google, Facebook, and Twitter have more power over free speech and privacy than any government, but Google, Facebook, and Twitter are not bound by the Constitution. The Constitution only binds the government. It doesn't bind private corporations or private actors. So I think there might be a good argument that even James Madison or Thomas Jefferson would have been interested in the question of whether we should draft, propose, and ratify a new amendment that imposes the same requirements to respect free speech and privacy on really important social networks as are imposed on the government. And I love your question too, because if you accept my challenge, you could not only pick a current provision of the Bill of Rights. I said you should pick a current constitutional controversy that applies to your life. If you talk about that tracking on Google and Facebook, and you conclude that the Bill of Rights doesn't apply because Facebook isn't in the government, you could propose as part of your challenge a constitutional amendment, and you could even draft it. And I'd love to hear what the language that you came up with. So thank you for that great question. In the back, if we have time for just one more.
I think there can be an in-between side. Do you think there is?
Do you think? In between which positions?
Yes and no.
For things like the unconstitutional
for a case.
For a case. My answer is absolutely yes. I think there's always an in-between side. Whenever anyone tells me the answer to this constitutional question is clear, I reach for my wallet, because these questions are not clear. They are hard. And I think when you say an in-between side, often you can come up with a narrow rule or a broad one. So you might say, it's not okay for the government to track me just when I walk out the door because I'm wearing a funny colored tie, but it would be okay if they saw me making bombs, in the hotel before I came over here. And saying that there's an in-between side, I think is something that, again, James Madison would have very much embraced, because he was a constitutional moderate. This was someone who was resisting both the claims of the strong Federalists who said we don't need a Bill of Rights at all, and the anti-Federalists who wanted to have so little federal power that there was no ability to have a bank or wage war. He was basically thought it's a matter of compromising and pragmatism and balance. So even when you look at the word unreasonable searches and seizures, what's reasonable and what isn't reasonable could vary depending on the consequences and context. So all that's to say is, if you accept that challenge, it's not to say you got to come up with some answer. You can't say I don't know what I think, but you can craft a rule about when surveillance or free speech is permissible or not that is moderate, that takes account of changed circumstances, and could vary based on a whole bunch of other factors. So thank you for that. And with that spirit of moderation, I'm going to end once more with my exhortation. There's no greater privilege of American citizenship than studying the Constitution and the Bill of Rights. I feel lucky every day to be able to learn about it. I'm so excited to be able to learn from you about it. And I challenge you to go inspire students across the country to learn about the Bill of Rights as well. Thank you so much, and have a great day.